It's now my pleasure to introduce our speakers, and I'm going to introduce both of them, and they will speak in turn. First, Jack Faust is a graduate of Jefferson High School and the University of Oregon Law School. He is a senior partner at Schwabe, Williamson, Wyatt. He's a past president of the Multnomah County Bar Association. He is on the Board of Trustees of Lewis and Clark College. And, of course, between 1980 and 1993, he was moderator of Town Hall, which was or is a weekly hour-long public affairs television program on KATU television. Our second speaker is Forrest Rieke. Mr. Rieke graduated from Wilson High School, as well as Stanford University and Willamette University College of Law. He's a senior partner at Rieke, Geil, and Savage. He was the senior deputy district attorney in Multnomah County from 71 to 1976. He's a member of the board of directors of the Mount Hood Ski Education Foundation and was a member of the Board of Education of Portland Public Schools between 1978 and 1993. Our topic today is trial by media, how the intense coverage of high-profile cases is changing our justice system. Just over 2 years ago, CNN and Court TV carried live broadcasts of the William Kennedy Smith rape trial. Since then, media coverage of high-profile cases has skyrocketed. Portland was the site for a feeding frenzy during the Tonya Harding saga, and this summer, all three networks preempted hours of daytime programming to air the O.J. Simpson pretrial hearings. The American public has been a willing consumer. The Simpson story has drawn huge ratings and readership. But the jury is still out on how the magnifying presence of the media microscope is affecting our ability to deliver justice. Jack Faust, attorney and former television host, joins Forrest Rieke, a criminal defense trial attorney, to examine the issues raised by increased media involvement in the legal process. Has the judicial process been turned into a public spectacle? Does such intense coverage make it impossible to find impartial jurors? Or have television trials helped educate Americans about our legal process? We are about to find out. Mr. Faust.
Thank you, Alan. I see that we are videotaping this for Penthouse Magazine, I assume. And it's a pleasure to face an audience that can't turn me off. I'm used to speaking to television viewers and judges who can turn me off. Our topic today, let me tell you what it's not. It is not cameras in the courtroom as such. That's another topic, and that's quite a topic. What we're going to focus on is this extraordinary coverage, maybe you might call this exploitation of trials by the media. I will give somewhat of an overview, issues, observations, and Joe, who is an excellent and very experienced criminal defense lawyer, will follow, emphasizing some of his real-life experiences. First, when I say media, what are we talking about? Talking about the television, news, specials, tabloid TV shows, such as Hard Copy, talk TV, such as Larry King and Town Hall, yes, you, Frank, and the print, too, although let's not forget the print in here. Although we're talking about television, let's not forget the print. The magazines, the papers, and the tabloid papers are part of this feeding frenzy, although certainly the emphasis is on television because it is a fact. I think that while the print can do a great deal in depth, that they cannot match television in immediacy and emotion. And that's why we're talking and featuring television. The message, that's the media. The message, interviews with the principals, witnesses, advocates, and paid interviews. You'll hear me make some reference to paid interviews here. Analysis, experts, legal expert, you'll see the caption on somebody, speculation, and dramatization, graphics in the front page of your paper, and the reenactments, that sort of thing. And I have here a quote from a 1963 NBC News Department memorandum where the author urged the staff to, don't forget, we must serve truth responsibly, but said every news story should display attributes of fiction and drama. It should have structure and conflict, problem and denouement. What is the impact of this? Certainly there is a factor of education. I think that television coverage has done a lot to change people's idea of what goes on in a courtroom. I think there is more of an idea of the reality of what a court process is than we ever got from the movies, which shows something and continue to show something that has no relationship whatsoever to the judicial process. But with the overemphasis this feeding frenzy that we're talking about on the big cases come dangers. First, to the public in general, I think that this creates a heightened perception of crime and violence, that it's everywhere. Give a lot of publicity to Jeffrey Dahmer trial, and people who live alone on a mountaintop will lock their kids in. There's more fear, there's more concern. Now the justice system. Let's look closely here. There are effects before the courtroom doors ever open. In civil cases, defendants frequently settle because they say, we don't want the publicity. We just can't stand the publicity of that kind of a trial, so they pay money to avoid it. In the criminal area, prosecutors, there's a decision that has to be made. Do you prosecute or don't you? Oftentimes, you're going to be influenced by the fact, how popular does this defendant have to be? Everybody's willing to prosecute the local drug king, but what about the high scorer on the Blazers? How eager are you going to be to prosecute him? So those decisions. And for the defense as well, considerations of can we survive this case, or should we plea bargain? Judges, there's tremendous pressure on the judges in their rulings. This is true primarily in the criminal area, and you can see a thing with this enormous publicity. Picture like, say, the Charles Manson case. The camera, here it is, the whole world is waiting, and the judge throws out all the evidence that is going to make the case for the prosecution. What kind of pressure is there on an elected judge, and not just elected judges, but even federal judges who may want to move up the ladder in the federal system, and they recognize that as they move up the ladder, there will be comments on them by the Justice Department, that is the prosecutors. There is tremendous pressure for law enforcement, and in some cases it's conceivable, I think although less often, that there can be cases where the pressure would be to rule for a popular defendant. But most often it's law and order pressures that are felt by judges in their rulings. Jurors. There's no question about the influence on jurors where there's this enormous publicity. You've all heard the joke, knock, knock, who's there? OJ, OJ who? Okay, you can serve on the jury. There just aren't going to be any of those people around in this one. There's intimidation of jurors by this. We had a Florida case where the jurors admitted that they convicted a policeman for shooting someone because they were afraid there'd be riots if they didn't do otherwise. Also, and here I come to a specific comment on paid interviews. There could be an attraction to jurors. Boy, if I go on that OJ jury, when I come out, I'll bet hard copy would give me $250,000 for an interview. You could have jurors who actually conceal their prejudices to get on juries because they want that fame and that money. Witnesses, much the same thing. Possible intimidation of witnesses, afraid to give unpopular testimony in the spotlight, and again through witnesses, perhaps an attraction. Gee, I could be the key witness, lots of money. Sell my story everywhere, books. And counsel, Joe will talk more about this, but there's no question that there is a pressure in these cases to try it to the public. In criminal trials, the defendant in the media does not get a Fifth Amendment. In civil cases, there's no such thing as no comment. That's an admission. So there is the pressure to try it to the public, and oftentimes lawyers really don't want to do this. And a lot of times in cases, you don't want to tip your hand on something, but there is that pressure, gee, we've got to answer back and forth whether we like it or not. And this can actually affect the way cases are tried once it gets in there. We just saw this recently in the Simpson case, where the prosecution did not use a woman's testimony before the grand jury because she had been on hard copy, I think it was, and she'd talked to the tabloids, and she'd received several $1,000s in fees. And they felt that her testimony was tainted by that fact. that she would have less credibility for that. As to the principles in the wrap-up, well, on every featured case, at the end there is a public verdict that's separate and independent from the verdict in the courtroom, and there is no appeal from that. I pay particular note here again to what I think is a particular evil, and that is these paid interviews. I've noted how people may be drawn into the process, how it may affect their conduct, just the idea of making some money. And there's another impact of that as well, and that is that this denies the access of the legitimate reporters to these people. They're going to have the exclusive story next week on hard copy. So when legitimate reporters come up with questions, it's sorry, give an exclusive, sorry, give an exclusive. Now why do we have this kind of intense, unprecedented coverage, television and in print? It's not because, I'm speaking here from the local media, it's not because people in the media that I know like it. I don't know anybody in the media who likes this. I think the number one reason boils from this. Bill Cosby said, television is business and business is America. The United Way does not send checks to Channel 2 or the Oregonian. Television survives on advertising revenues. That's their lifeblood. Advertising revenues come from ratings, not from awards, from ratings. The print survives on ad revenues, which are tied to circulation, and on sales. So forget what those polls tell you. The polls, you ask people, say, oh, no, we don't like that sensational stuff. We pay no attention. We hate that stuff. Forget it. They vote with their feet. What you see on television is what people are watching, what the public is watching. What you see on the newsstands is what people are paying for. And then you say, well, but they go so far. Television, we talk about the case of trial by media. They give a verdict. They don't have to do that. They're giving a verdict. They're reaching conclusions. Well, let me tell you also, the public wants answers. One of the commonest complaints we got in town hall, people would say to me, but you don't resolve anything. And I'd say, we try very hard not to. We try to present both cases and let you resolve it. No. They wanted me at the end to say, you win and you lose. That way. They want answers. There's another reason for much of this coverage, the kind of coverage you see, and that is the tabloid journalism is cheap. Tabloid TV shows are cheap to put on. There are a lot, even if you pay $100,000, $200,000 to someone to come on, it's cheaper for the exposure you get than highly paid stars, high production costs. They're generally cheap. So what to do about this to try and rectify the evils in the system? Well, I would say first, let's not forget that we have some important values here in freedom of speech, freedom of press, and the principle of open trials, all of which are in our state constitution, I might say. And I would say I'd hate to see anybody be tampering. I'd hate to see the law and our government start tampering these, because I think anytime you start even setting up a process for limiting speech, the press, we're threatened. If a process is in place, we could have a greater evil than the evils involved in this coverage. So what we're left with are voluntary restraints. Bar associations can tighten the rules on commentary to the press, but really that's probably not going to make a lot of difference in these big cases, because if the lawyer comes out and says, I won't comment, they'll hire somebody to do it. And you'll see legal expert, and they'll say, well, now from Simpson's standpoint, what do you say to that? And there'll be someone, in effect, playing the role of Simpson's lawyer. So I don't think that'll make a lot of difference. For the media, voluntary restraints, I think given the competition today in the media, the tremendous competition with all the channels, all the sources, magazines you have, that it's probably unrealistic to expect anything but minor controls here. A suggestion has been made for labeling. For example, if you're paid $250,000 to talk on Inside Edition, that they would put up a card and say that so-and-so was paid $250,000 for this appearance. Those things are minor. So to look to the future, well, this may be cyclical. If we remember, it was over 100 years ago, the huge national uproar over yellow journalism. That's where that came up. Quotes like the press is a wild animal, it's a tiger, etc., things like that. And it was over 100 years ago that Joseph Pulitzer established his prize to try to counter this fear of yellow journalism. So it may be cyclical, and I think you also have to say that we have had, in the last few years, some extraordinary cases that are the stuff of real drama. I mean, think about, just say, for example, what's on all our minds now, the Simpson case. Think of the last case you can think of where such a famous person was accused of murder. And I don't mean someone who becomes famous by being accused of murder, but someone who we all knew, who'd been in our homes, who we felt we knew, who was suddenly and unexpectedly accused of murder. Think of the next most prominent case like that. I suspect you'll think a while. So in the near future, I think it's fair to say you're not going to see much change, and for the most part, I think we'll have to live with it. And with that, I'll turn over this microphone here to someone who lives with it every day, Joe Rieke. Joe.
This club is interesting in terms of when it makes the call on who should speak on a topic. My career has been blessed with almost no contact, fortunately, with the media in a case. So my perspective is entirely a sideline look at this. We should all take a minute to say, Jack, thank you. You didn't resolve anything. That puts the ball in the court. Jack and I discussed this at lunch to try to figure out how to present this topic, because to you it may not seem as significant or as massive an issue as it is. It's remarkable how much time people in trial work spend trying to anticipate what a fact finder is going to have on their mind before you start the discussion about the case. And I would suggest to you that perhaps the perspective I would urge on you in terms of deciding what should be done in this instance is to take a moment and place yourself in that position. There is no question that the fact finder is one of two groups, or a group and an individual. In a criminal matter in particular, but true in a civil matter as well, the fact finder is either going to be a judge or the fact finder is going to be a juror. Jack is correct in terms of trying to accomplish any conversation levels at all. We cannot go into what happens during the course of a trial, although there's some interesting things that Judge Ito is already doing to contain the press who has been admitted to the courtroom down there, and I urge you all to watch that, because the eavesdropping capacity of the microphones is a remarkable problem. But speaking strictly to the business of pretrial publicity, and looking for a minute from our perspective, which frankly is going to be one of media bashing, which is not a natural fit for me, although my record with the media is not all that good. I would say that this club, having me speak on this, is interesting, because one of my favorite stories about my mother, who was a legislator in Oregon, was that in the 50s, she always liked to come to listen to the speakers at the city club, and very much appreciated the fact that she was allowed to hear these speeches while sitting at the press table, because that was the only place a woman was allowed to sit to hear the club. We've come some distance since that warm feeling we had about the press at the Rieke House, because there are some things that are emerging in the press's capacity to deal with issues that in fact has begun to make things extremely shaky for those of us who are trying to preserve really some rather interesting traditions. And those are what these are, these amendments that are the personal rights of accused as well as personal rights of us all. The notion that you're going to have a public trial in this state is almost religiously protected by appellate courts. The case that you may all remember that even opened the juvenile proceedings to the press is not that old in Oregon, but when a case was taken up, it was the Michelle Gates case was taken up for consideration at the appellate level by the Oregonian as to whether or not they could have a closed hearing on a youngster who had been charged as in that case with murder. Whether that was a protected hearing, the appellate courts frankly stated it was not. So that the right to access to the process by the media is a favored right in our system. It may or may not be absolute, but one wonders when you operate from the position we do. What you need to recall is that much of what has been accomplished in the way of protecting individual rights since the 50s and 60s by the courts has had to do with a concept known as the motion to suppress. That is to say, the policeman, if he blunders, is not allowed to use the evidence against the defendant. The protection then provided by that motion to suppress is rendered almost meaningless, of course, if what you discover is that all of that evidence is presented prior to trial in the newspaper or on television. And Jack raises the point, and I think it's the one that we all of us are going to have to come to grips with, which is what exactly is our feeling about the level of protection we want for the individual as against the state. And in part, in trying to think about that, I had a chance to talk with John Painter, who is a Neiman fellow, and he sent me a Neiman report from spring of 1994, in which there is a series of statements in there about these balances, but his description, and he wrote a very good article on the Tonya Harding case, of the Oregonians' confidence at being able to use unnamed sources repeatedly in the Tonya Harding case was that they had great confidence in their sources, that their sources ran so deep and were so thoroughly involved in the day-to-day business of the investigation that they were able to continuously be right, even though they were naming unnamed sources. And that apparently rationalized the process of being installed inside the investigation. This, you understand, from a group of people who want their sources protected, so that when we later ask, where did you learn of this bit of evidence, they're going to tell us that they'd rather go to jail than tell us that. I suggest to you that infiltration is going to come a cropper eventually of some serious analysis by judges, because obviously what is going to emerge eventually is going to be evidence that may or may not have been right or correct or admissible or even true. And as you reach those levels, you begin to see that there's going to be tensions that get beyond just yours and my personal opinions. I did want to take just a second and quote some interesting people on this topic who are telling us at least the nature of the problem. First of those, if you don't mind, from a lawyer who is busily getting a lot of attention, who is Judge Ito, down in O.J.'s case, in that hearing in which he issued an order about whether or not the photographs of the decedents would be allowed to be handed to the media. He disallowed the photographs being handed to them. And his statement in the order, I think, is pretty exciting. He says, most of the news media accounts have been factual. However, there are glaring examples of rank rumor and speculation, prurient sensationalism, and outright fabrication that are the result of competitive commercial journalism. That's a pretty exciting statement out of a neutral observer. The concept of prurient sensationalism, turning an investigative reporter into a sleazy pornographer, is an interesting twist of phrase, and I'd suggest to you that degree of animosity found in that language is the precursor of some interesting material that's going to come out of O.J.'s case, clearly. We've already seen an act that would be unprecedented here, which was that the court, if you noticed, completely removed the matter from the grand jury. In other words, disallowed a constitutional body to consider the evidence in that case based on what he felt would be a control, or they felt would be a control issue in terms of the evidence presented. So we're seeing some rather interesting new interventions, things nobody had ever seen before already in L.A. To follow that, just briefly, let me quote some people from the news that were in the document that John sent me. A fellow whose name is Michael O'Neill, and he was the editor apparently of the Daily News of New York, indicates that the conflict comes this way, that something has evolved such that it creates a substantial probability. I'm sorry, wrong thing. Actually, the conflict is actually masking a new, deep, and troubling trend in the relationship between American society and the whole broad spectrum of institutions by which it is informed. Trends that can be most clearly in the merger of news and entertainment, most clearly be found in the merger of news and entertainment, in the casual replacement of fact with fantasy and fiction, in the blurring of the lines between what is real and unreal, between natural occurrence and synthetic event. To add to Jack's thoughts about the economic cause of this, a man named John Malone, who apparently is an entrepreneur in telecommunications, bluntly states, nobody would invest hundreds of millions of dollars for the public interest. One would be fired if he took that stance. That's inside the media. Finally, another observation by the LA Times fellow David Shaw, who says that much of the problem has to do with an ethical one in which the traditional gatekeepers of the news, the editors, are letting trashy tabloids set the news agenda. The point is you can, I think, assign the responsibility for what's happening in a number of places, and I'm not sure that we get to have the luxury of simply assigning responsibility. We've got to take responsibility in this matter and deal honestly with what we know. Let me just briefly cover what we know. One of the things we know is that, of course, juries, for the most part, cannot be interviewed in most jurisdictions after the fact. They have to be left alone. They are protected individuals, and so much of what has been studied to determine whether that there is an impact on juries is sort of secondhand. They've used moot juries, mock juries, to evaluate the impact of public behavior. There is, however, some evidence, at least there were some that emerged out of the South, in which when a study was done after an individual woman had announced that she had lied about the identification of an individual who raped her, and the case was reviewed actively in the press. There apparently is an effect, or was an effect in the case there, that subsequently there was a distinct evidence generated in subsequent jury cases that at least ID identification cases suffered at the hands of that publicity. That is to say that fewer people were found guilty in ID cases. Interestingly, nobody can find a similar example from just doing straight statistics of the outcome of what happens when you go through a series of very serious and ugly homicides and then try to look for a hardening effect. There is a leniency effect, but nobody can find a hardening effect of juries after that sort of publicity. The second thing we know is that the publicity can either be direct or indirect. And I would suggest to you as a practitioner over the last 20 years or so, it's clear to me that the indirect is as effective in affecting the fact finder as the direct testimony of those who are going to testify in the trial. By that I mean the war on drugs, the sense that the drug thing has gotten completely away from us and that we're overwhelmed by it, distinctly emerges when you're discussing in voir dire with jurors their feelings. Many of them actually remove themselves from cases, indicating that they feel so strongly about drugs they don't think they could be fair. I assure you 20 years ago that wasn't happening. Similar examples of the day-to-day kinds of pressures that jurors feel can be found, I think, in the examples that had to do for years with how do we feel about women and how do we feel about rape. There's been a distinct turn, it seems to me, in the public's feeling, much of that induced by the press. More recently, we've been dealing with child abuse cases in which a number of rather interesting generalities like children don't lie about these things have become internal beliefs of the people we interview in juries. Those are concepts brought forward by media exposure. They are indirect, and in my estimation at least, they are having an effect on the outcome of cases. More direct examples of evidence being studied that where the evidence was in fact factual just before trial. It would appear that the studies done are not particularly convincing here, but basically what they say is that evidence that was factual in nature actually can be alleviated, or some of the damage can be alleviated by delaying the trial. Those same people that evaluated that material, an outfit called Kramer, Kurz, and Carroll, also concluded, however, that emotionally specific material published before trial simply can't be eradicated by judicial behavior. And what they're talking about, of course, is the mother's pleading story about the youngster who's been run over in a hit-and-run accident just before trial on television is not something that the judge can eradicate. And the tools currently available seem to be sort of three, one of them, or two of them active, one of them passive. One of the active tools is to give direction to the jury in what are called jury instructions to disregard those things they've heard outside the courtroom. The basic effect of those, according to those people who've studied juries and jurors, is that that has virtually no effect. The second category of activity is the judge delaying the trial. In the case of a factual introduction of evidence in the press prior to trial, that seems to have some effect, but no effect apparently on the emotional pitch made by media if that's made before trial. And finally, the business of deliberation itself. Many people will tell you that their belief is that the jury is important because the jury can deliberate and eliminate these prejudices that they each share by the deliberation process. In other words, that they're going to get rid of this just by simply sitting down together and collectively analyzing the facts. Apparently the studies done on the process that is the jury process have in fact thrown that notion out entirely. Apparently it's quite convincing that the process of a jury deliberating is in fact a group dynamic in which those things that are polarizations that exist before the jury starts become magnified by the process, not reduced. I tell you about those studies only because they are perhaps for the most part unrealistically clear about the fact that nobody really is sure about the jury except those of us who practice. And therefore what you have to do is take my opinion and accept that as gospel and disregard the studies. I guess one other point I'd make that Jack has already harped on to some degree, but I think it's important to think about, is that there is this distinct problem with how much sensational attention these things get. It is interesting that the Harding case nationally received a 45% rating. That's nationally. It would be interesting to see how it would have done in Oregon in terms of trying it against, for instance, the Gulf War getting a 70% rating. But more relevant is the Mendez trial. The two young boys who killed their parents down in California got only a 12% rating, and the Bobbitt penis amputation, which I would have thought was highly visible, had only a 26% rating against the Kerrigan-Harding 45%. It is clear that at some point the case gets away from us in terms of how it is that the defense attorney approaches the matter. One asks then, what does defense attorneys do about protecting the rights of the accused? And frankly, Jack has made it clear that unless we do something, nothing appropriate is going to happen in this area unless everybody volunteers to do it. And my expectation on that is not great. Essentially what we do, I believe, is to suggest that the motion to suppress perhaps has in it some mechanics that should operate in this field. By that I mean we should perhaps have the courts evaluating whether or not leaks out of the police bureau, out of the prosecutor's office, that generate factual information that is published in the community should in fact be evaluated for purposes of disallowing its use at the trial. The concept frankly scares the hell out of people, and I appreciate how little appreciation the public has generally for the motion to suppress, but I can assure you that it's had a material effect on police behavior, on such things as one's right to give a statement or one's right to have their Fourth Amendment rights protected. That is to say that we have a Bureau of Police Standards and Training in Oregon today, not because anybody thought we needed professional policemen, but because they couldn't get their evidence into the courtroom without educating the policemen on how to gather evidence legally. My estimation is that there is perhaps some value in considering the motion to suppress and the suppression process as a penalty for behavior of the sort of spin technology that seems to be emerging in prosecutors' offices today. The other possible analysis that needs to be given to this whole conversation is whether or not, in fact, because these are civil rights that are the protected rights of individuals accused in crime, although most of those individuals make rather unsympathetic plaintiffs in such cases, one wonders whether the Civil Rights Act shouldn't be altered to some degree to deal with the economics that the press is bringing to this conversation, and that is to say, allow us to sue the press for the violation of civil rights that occurs by virtue of the press's mishandling information that should have been protected. An example of when that might have come into effect, for instance, is the what is his name, the singer in California? Michael Jackson, whose case was fascinating in the respect that apparently the victim in that case was virtually unknown to the press and had been protected significantly by the agents of the state until Splash News, who is a British operation, somehow managed to get a hold of, through theft, I am sure, the CSD reports about the victim. The CSD reports were subsequently sold to any news media unit that wanted them for $750, which was the cost of faxing the CSD report to the other news media. As a result, a great deal was suddenly known about the victim in that case. The other interesting high-energy issue in that case was the opening price of the young woman, or the middle-aged woman who was apparently the house cleaner or matron there at the home, whose opening price, as I understand it, was $900,000 for her story to the news media. Point is that we are dealing in an area where the press does, in fact, take an active role, actually carries out acts of privacy invasion that may well be subject to, or should be, some analysis by legislators on the question of whether or not civil rights protections need to be set up to curb excesses. Having offended you all with those notions, because you all are strong believers in the First Amendment, let me just suggest that the best way to get to your questions and get this thing focused in a way that'll do us the most amount of good, I think, is to stop at this moment and let you ask us what you'd like to know about this topic. I would tell you that the pressures that we've described, Jack and I, are real. I cite as an example, one last one perhaps, the recent case handled here that had to do with the youngster that was remanded in the case involving the assault by several youngsters over at the Lloyd Center. 3 youngsters were ultimately arrested in that case. The 2 most responsible youngsters were not remanded by the judge, a senior judge who has been at this for some time, a very good judge. The 3rd child was remanded into adult court, to everybody's surprise, but only after there had been an extensive outcry by the DA's office about the inappropriateness of the finding of the first judge. That had reached the newspapers. The individual who made the subsequent decision is a fine judge also, newly appointed, however, and about to run for election, who remanded the 3rd youngster, and one might speculate that there is a real issue here about pressure of the community being brought to bear on people who have to run for election after having done something that perhaps would have been unpopular. So I do think that these are real issues. That's a fact finder, and the judge's dress, the judge's black cloak, and it's a fact finder under pressure. I do believe that we have an issue here that is significant, that civil rights are not necessarily popular. It is interesting, frankly, that if one really were to talk about civil rights lately with most Americans, one would probably discover that the 4th Amendment is up for repeal. The right to have search and seizure issues result in suppression. Frankly, I think the public is ready to drop that altogether based on their concerns about drugs. But allow me to suggest that all of you have a role to play in the analysis that goes into protecting these rights, and from the standpoint of those I look after, it's become extremely important that we have an environment in which these cases can be tried, because not only is the media becoming more complex, but frankly, so are our clients and their problems. And the guilty but insane area that we operate in now is so completely afloat that we need an environment that's both calm, deliberate, and able to operate intelligently. And frankly, what the media is doing to us is not helping. Thank you.
Thank you, Mr. Faust and Mr. Rieke. Our first questioner will be Pete Heuser of the board. After Pete's question, Jonathan Ross will ask the second question, and then City Club members may line up at the microphone. Please introduce yourself and tell us your affiliation with the club. And please remember that questions have a question mark. Thank you.
You've both addressed the issues of what can be done to limit damaging pretrial publicity. I think you both addressed what courts can do. I wonder, Mr. Faust, could you touch briefly, I think, upon the appropriateness of gag orders and the effectiveness? I wonder if you could follow up on that. Are gag orders appropriate if the lawyers and paid consultants are told not to talk about the case? Are they appropriate? Would they help? Mr. Rieke, I wonder if you could comment a little more about the existing O.J. Simpson trial. You mentioned that Judge Ito had limited some aspects that might prevent eavesdropping. What else could he be doing or might he do in the future in that case to limit damaging pretrial publicity?
Well, I think Joe, I'd be interested in your ideas on the gag order, but it seems to me I'm somewhat reluctant on those again because I hate to interfere with speech, but there is a use for them. For example, if you have some evidence that's been argued about that everybody knows isn't going to come into the case, and I think a gag order is appropriate to see that somebody doesn't go out and give a press conference and talk about that evidence or something, things like that. I think they can, where there is really this explicit danger. Now, if you're talking about a gag order such as they have, I believe they did have in England, where they can actually censor the press, so to speak, order no publication on something, I would be opposed to that. I think, again, that would lead to greater evils than the evils we've just been talking about.
To try to respond, Jack, the gag order enforced in a conversation between counsel and His Honor, in my estimation, would probably be obeyed with great care. Specifically, talking about Ito and his behavior in the case of O.J., he said about the photographs that he felt that they would create a substantial probability, and in this case a virtual certainty, that the defendant's right to a fair trial would be similarly prejudiced. A man who felt that strongly being defied would be a dangerous act as far as most attorneys are concerned. The other thing that was going on in the O.J. case that was interesting was that apparently the technology of getting microphones on the same desk where a defense counsel is talking to his client resulted in their having overheard apparently some conversation between, they being the media, having overheard some conversation between O.J. and his attorney, Shapiro. That apparently came to the attention of Ito, and he made it clear that his response to that, were there any more of it, would be immediate removal of the media from the courtroom. Basically, I think the situation that has to do in and around the courts is not so problematic as those circumstances that have to do with outside the courtroom. And I cite, for example, intriguing numbers that had to do with Tonya's case. I mean, if you're talking about gag orders, can you imagine the frustration of a bunch of attorneys trying to tell their clients to be quiet? And Stant and his friend, I forgot what his name was, got $50,000 for their interview. The husband got $175,000 for his, and Tonya got $300,000 for hers, all prior to any trial. One has to wonder exactly what control one does have over those who are the players. I frankly can't tell you that I know the secret to the gag order process, but I do not believe it will reach effectively such things as police forces. And much of what seems to be the case that concerns me is that the investigative process is being invaded by investigative reporters who have befriended specific players inside the Bureau. And that process, I don't think, would necessarily be reached by a gag order, which is why I suggested the motion to suppress.
Hi, I'm John Ross, City Club member and co-chair of the Technology and Business Issues Committee this year. I'd like to thank you both for a very interesting and stimulating presentation. And the question I'd like to ask, at the risk of sounding a bit provocative, And I suppose you should know that I have been a practicing attorney and am not now. Given the legal profession's demonstrated capacity to value its own services very highly, would voluntary restraints imposed on themselves by the bar or urged on other players in the drama, like witnesses and jurors, have an icicle's chance in hell of being effective at all? If not, what might be the role of the Oregon State Bar in regulating the activities of these players? Thank you.
Well, the state bar could go back to more restrictive rules on comment to the media. The present rule is that you cannot make a comment that may affect the fact-finding process if you do so with the intent to affect it, or if you have reason to think, good cause to think it would, and you act recklessly, so to speak. It's a standard that you either have to intentionally or recklessly intrude on the fact-finding process, something that's probably difficult to enforce. You could tighten up that standard and just say that there can be no comment whatsoever in the merits, and you could even put limitations. So when I first practiced, I don't remember what the restraints were when I first started practice. It was shortly after the Civil War, but we were more limited than now, and I remember it was just the general feeling that we felt when we were talking to the press, all we could talk about was to give them the record. We could comment who the parties were and what the pleadings said, but we couldn't get into anything that smelled of getting into the merits. So you could tighten that up, and indeed the bar could enforce it. But as I said before, I think that if you're looking for miracles to come from that in these highly publicized trials, forget it. You'll see somebody on there who'll be saying just what the counsel would have said.
I guess the other point here is that if you were being provocative to Jack and I, when you were suggesting we have a high sense of ourselves, we don't find that controversial at all. We're very comfortable with that concept, and that the other thing on what the bar can do, the bar has maintained a press bar committee, and a set of guidelines have been created, which are magnificent for their regular breaching. So for the most part, certainly on the voluntary level, we haven't had much effect on either side of this. One of the interesting questions you raised there, though, is what is going to happen when attorneys begin to try to put a spin on what's going on in these outside the courtroom. And my guess is that the bar will eventually begin to have an opinion about these things. It was an interesting period we went through there when Ron Hovitt was being examined for his comments. It is clear that there's nothing wrong currently with what he did as far as the bar is concerned. There were a number of attorneys, however, who felt otherwise, and there'll be an interesting ongoing debate over that.
Frank Munjum, member. I have a question for you, Jack, on your knock-knock joke. The idea of, in terms of the issue of impartial jurors, would we really want a juror who knew absolutely nothing of all the coverage of that case? How good a juror would that be? And I wonder, aren't jurors capable of being exposed to coverage on these issues and still be able to to deliberate in a fair manner?
Well, the exposure, let me take your last, the exposure on the jurors, well, first, let me take your first question. That's a fair question, and much has been written and said about that, about the undesirability of having people on the jury who are so out of it that they don't know who O.J. Simpson is. I mean, that is really not what you're going to call a high intellectual level of fact-finding in such a case.
It is, however, exactly the level the defense would like. If we could get it.
But if you say, well, and there are people, and I think for the most part, jurors really do try to do what is right. But you can have publicity that with such an impact that really there's no getting away from it. For example, if you show the pictures, like the pictures of the bodies, and you show, like when we had here the children who were thrown off the cliff years ago down here at, if that sort of thing were on television, people were seeing that regularly, I think there are very, very few people who could get over that impact. And Joe is right, a lot of people will just say so. You see jurors come on, just say, I don't think I can give this person a fair trial. But others may kid themselves. Think, yes, I can. But a lot of that is just hard to get away from, even as dedicated as you may be to doing your job. there's an impact.
That was addressed to you, wasn't it?
Well,
You've
you've got the microphone too.
Mike up.
We were just talking about the line before in the movie where he says there's not room enough in this town for 2 doctors and 2 vampires. Well, you've got 2 lawyers here. I don't know if there's room for us or not.
Thanks. I believe there's also a joke about the fact that if you have a town with only 1 lawyer in it, he goes broke. It's not till there's 2 that you actually can make a living. I think the sense of juror preconditioning, it would be naive to suggest that you can get total ignorance. I think the issue is more specific than that, which has to do with whether or not information about the case has gone into their heads that is external to the courtroom effort. And the general attempt to protect jurors from those preliminary issues is been more important since the motion to suppress has taken effect, and that is because there are certain things that a jury is not allowed to find out. Nobody, I think, that handles jurors has the slightest notion of which things necessarily are going to poison the well. A fascinating story that R.E. Jones tells of a jury that came back with a question for him in a case where he had there was a photograph of the deceased whose body was sort of laying out of a car. The photograph went back into the jury room. They came back out, and the question was, what kind of cigarettes does the defendant smoke? And of course, everybody in the courtroom couldn't do a thing with that question. The judge told them to go back and deliberate and don't bother him anymore with stupid questions. When they came out later, it turned out that there was if you looked very, very closely at the photograph, there was a Chesterfield right at the foot of the deceased, and apparently somebody was going to make that an important piece of evidence that nobody in the courtroom had seen coming. All I'm suggesting is that jurors are very complicated operations. Juries they are very busy with their own input, their own analysis of the case, things that the fact finder find that some of the rest of us didn't see. It constantly surprises me. So it's not really fair to say that these things are one-to-one in terms of the effect. It is fair, however, to say that at some point the pressure, the exposure becomes an issue in terms of being able to get a fair trial. And that's, I think, the only point we're trying to work on here is how much is too much.
The jurors also will try to get all the information they can from any source to make a decision once they're there. That's a common tendency. For example, jurors during the break, recesses in the trial, will pay attention to the people that are around the different parties. And if you bring in a criminal defendant, Joe brings him in, gets them all haircut, puts on a nice suit and all, brings them in, and then at the first break up come a lot of people who look like street people or druggers or whatever you've got, and the jurors see that, and they take that into account. It has nothing to do with the rules of the game, but they take what information comes.
We have time for one more question. BJ?
BJ Seymour, a City Club member. There seems to be some feeling, for example, that Mothers Against Drunk Driving have had a real impact on getting more convictions of people who drive under the influence of alcohol. And similarly, there's some feeling that the women's movement has had an impact on such things as the Simpson trial, where people are more aware of wife beating or spouse battering, and more concerned about that. Is there a role for education of the public in some ways mitigating the impact of the media?
How do you, BJ, what do you mean education, when, where,
Well,
how?
if, for example, you get more convictions of drunk drivers because Mothers Against Drunk Driving are out there getting their message across, that drunk driving is serious and that juries oughtn't to be thinking in terms of, oh, well, it could have happened to me, I could have had a couple beers and hit somebody by accident. There seems to be a tendency, I think, for people to be tougher on drunk drivers, for instance, since MADD has had its publicity campaign. Are there campaigns of that sort that could be mounted in other areas?
Oh, I think Joe could tell you, there's no question about that. And you can ask Joe about the impact of defending people on those, and he'll tell you, sure, there's a difference, because what you're talking about there is really what I've seen is sea changes sometimes in the public attitudes on something. I can remember when drunken driving was a joke. It was funny. Jack Benny used to, when we were kids, listen to the radio. Jack Benny, that was a common staple of the comedy, was Phil Harris driving around drunk. And drunken characters in movies were funny. That isn't that way anymore. You have a whole change in the viewpoint. And that, Joe will tell you the impact of that on juries.
Yeah, I resent it. It's having it convicts my clients. Yeah, listen, education is exactly what the media ought to be about. I guess the issue here is when they choose and how they choose to educate us. The issue is not so much here about continually bringing to our attention the ravages of alcohol and drugs, which are clearly having an effect on our society. The issue here is doing it the day before I have to try a DUIL case, okay? And I guess the issue is how best to regulate the volume of the assault, because at some point it does invade the jury room directly. Indirect effect, I would say, there probably isn't any way in the world for us to fairly limit the press on these very important issues. And the fact is that society grows by the fact that we have this great media coverage. There's no question about it.
That's a
So
great
it's
example that BJ gave. I think the growth of our attitudes on alcohol.
Sure.
That's with some bad cases for you, Joe, but a tremendous positive impact on society in general, no question.
I'm afraid we've come to the end of our time. I'd like to thank our speakers, Jack Faust and Forrest Rieke. Thank you very much. We're adjourned.